morning, everybody. Thanks for attending our presentation today about the current state of waters of the United States, or WOTUS, and implications for managing water and nutrients arising from the recent Supreme Court decisions and the focus on water quality. Today I'm co-presenting with my colleague Karen Olson, who's an attorney with the Spencer Fane Law Firm in Minneapolis. I'm a wastewater treatment process engineer with Geosyntec, working in the agribusiness sector. Karen previously worked at the Minnesota Attorney General's office, where she represented the Departments of Agriculture, Pollution Control, and Natural Resources. Throughout this presentation, we'll be each providing our own perspective on issues and solutions, and hopefully will help you see how an interdisciplinary team encompassing attorneys and technical professionals can help navigate this evolving issue. So we plan to cover 3 different areas in our talk today. First will be an overview of the Clean Water Act and 3 recent Supreme Court decisions and how those have changed the regulatory playing field and how they may impact you, the current definition of WOTUS, and how non-point discharges could require an MPDS permit. We'll also talk about early opportunities to look at the situation and figure out what you can do to protect your operation and to be part of the broader solution.
So as you probably know, the Clean Water Act prohibits the discharge of pollutants from any point source into navigable waters unless you have a permit. What people might not realize, this law has actually been in effect since 1948. And in 1972, however, when there was a lot of different environmental laws enacted, it was overhauled, and it's what is now known as the Clean Water Act. So like a lot of laws, and particularly the Clean Water Act, the definitions are key to understanding what it requires. So the terms discharge, pollutant, point source, and navigable water are broadly defined and have been the subject of much litigation essentially since 1972. The discharge of a pollutant is defined to include the addition of any pollutant to navigable waters from any point source. And pollutant, again, is very broadly defined. Any solid waste, chemical waste, biological material, rock, sand, rock and sand, which you might not necessarily think of as a pollutant, but it is, and industrial, municipal, and of course, agricultural waste discharged. Navigable waters means the waters of the United States, including the territorial seas. The term waters of the United States has been also the subject of changing definitions and much litigation, as we will see in this presentation. And just a little bit ahead, I do have the most current definition redlined on your table, which I'll get to that later because I'm going to kind of go through the history, not the full history, but part of the history. So point source then is any discernible, confined, and discrete conveyance, including but not limited to a pipe, a ditch, a channel, a tunnel, conduit, well, or container. But important for the agricultural community, at least right now, is the term does not include agricultural stormwater discharges and return flows from irrigated agriculture.
So Karen, I noticed that the term navigable waters is defined as waters of the United States, but does the Act define what constitutes waters of the United States?
Surprisingly and probably unfortunately, no. The term waters of the United States is not defined in the Act. Rather, the Clean Water Act gives the EPA and the Army Corps of Engineers the ability to define WOTUS through regulations, or more commonly referred to in Minnesota as rules, but it's interchangeable, so rule or regulation. And I would say this failure by Congress to actually define the term has led to a continuous changing definition as court cases come out, as we go into different administrations. So for the average person, it's very hard to determine what is the definition.
Well, it can be hard to know whether a water is subject to federal regulation when the definition is continuously changing.
Yeah, as you can see from this slide, it was initially defined in 1980. 3 court decisions, 95, 2001, 2008, impacted the decision. 2015, the EPA amended it. 2019, they put out a new definition. 2020, that was when Trump was last in office, there was the Navigable Waters Protection Rule, which then replaced the former definitions. And again, in January 2023, the EPA under Biden again amended the WOTUS definition.
Can you tell us a little more about the January 2023 definition?
So the paper on your thing actually does contain the January 2023, and as I'll explain, as amended in August. But the January 2023 definition included approximately 5 different categories. Traditional navigable waters, but there's a little tag along there, including interstate wetlands. So if a wetland crossed a state line, it's automatically going to be a WOTUS, whether or not it's connected to anything else. An impoundment, tributaries of traditional navigable waters or impoundments, but they have a 2-factor test. So they have to be relatively permanent, standing, or continuously flowing bodies of water, or either alone or in combination with similarly situated waters in the region that affect the chemical, physical, or biological integrity of traditional navigable waters. January 2023 definition, which causes probably the most problems for everyone, is the definitions of wetlands. And any wetland that was adjacent to a traditional navigable water or interstate waters, including interstate wetlands, are relatively permanent, standing, or continuously flowing with a continuous surface connection, or that significantly affect the chemical, physical, or biological integrity of certain waters, was included as a WOTUS. Todd, looking at these definitions, you see a lot where it says significantly affect the chemical, physical, or biological integrity of traditional navigable waters. That, I know at least when I'm drafting a legal document or I'm drafting a contract with someone, I'm not going to use the term significant, like a significant breach or a significant change in circumstances, because both you and I may have a very different view of what significant is. I mean, if you're the farmer, any change could be significant, but then if you're another party, you could say, well, no, it's really not significant. So what you end up doing is you spend a whole lot of time and money arguing about what is significant. So how about in the engineering field?
Yeah, as engineers, we're taught never to use the term significant unless we can tie some numerical value like a percent difference or a probability to it. So I would agree that using that term without some backup could be problematic.
Okay, there are, and still remains today, some exceptions to the WOTUS definition. And most of these exceptions are very helpful for the agricultural community. So the January 2023 exceptions, which weren't eliminated in the August 2023 amendment, included prior converted cropland that's designated by the Department of Agriculture, ditches excavated wholly in and in draining only dry land that do not carry a relatively permanent flow of water, artificially irrigated land that would revert to dry land if the irrigation ceased, artificial lakes or ponds, which a lot of people will put in their yards or in the suburbs and various places for homes, water-filled depressions created in dry land, incidental construction, swales and erosional features, and then of course items such as swimming pools. Todd, many of these I think are understandable, but at least for me, I guess I don't really know or could depict what is a swale or an erosional feature.
Well, a swale is a drainage feature that collects overland flow and spreads or retains it so that it will infiltrate into the ground. These areas tend to be low-lying and they might be marshy. An erosional feature is a depression created by erosion of soil by water or wind. An example of that could be a pothole.
Okay, and see, both of those seem to be good exceptions to the definition of a WOTUS, and that makes sense why they would be excluded. So, not surprisingly, as usually happens, when the January 2023 definition came out, there was immediate litigation. The American Farm Bureau was one of the primary litigants, along with various states, not Minnesota, of course, because you all know the political climate, but other states that challenged the definition right away. And in March of 2023, a Texas court enjoined the rule in both Idaho and Texas. And then shortly thereafter, actually one day later, a federal court in North Dakota enjoined the rule in 24 states. But the rule did end up taking effect on March 20, 2023. So we have 24 states implementing the January 2023 rule and 26 states using the pre-2015 rule.
What's been the impact of federal courts in joining the rule in certain states but not others?
Yeah, I mean, this is where you have the checkerboard implementation, right? So if you have a company in multiple states, you're subject to multiple different rules.
It seems pretty confusing, particularly if you're operating in multiple states.
So here's kind of a picture. So you can see the different states, and you can see like Minnesota has one rule, but then our bordering states in North Dakota, South Dakota, and I think it's Wisconsin, have different rules. So, you know, that very much impacts people's operations. This is also going to make for very inconsistent interpretations, because you're going to have different state courts and different federal courts applying different rules, and then how are you going to, you know, navigate all of that at the end? There's just going to be no conciseness or something that people can look to.
You mentioned there have been some Supreme Court cases that have impacted the water regulatory field and EPA enforcement. Can you provide more information regarding those cases?
Yeah, there's three I'm going to talk about, and these are actually really significant cases. I mean, cases come out every day impacting, you know, different rules, but these have really made kind of a landmark change. I'm going to talk about the County of Maui, and the County of Maui decision said a Clean Water Act permit is required when there is a functional equivalent of a direct discharge into a WOTUS, so you don't need an actual point source. Sackett in 2023 significantly limited what can be classified as a WOTUS. So, you know, that one's positive for the regulatory climate for people who are operating. And then Lopez, that overturned deference that had been granted to federal agencies, so that they can no longer, a court can't simply just say, well, that's the way the federal agency to interpret it, so we're going to defer. So the Sackett is probably the one that most people have talked about and really seen it as a landmark decision. It's got kind of interesting facts. The Sacketts owned an excavation company, and they sought to develop property. They were going to build a house, and the house was going to be a few hundred feet from the lake. And in order to prepare the ground for the construction, they began to fill the lot with gravel. Well, a neighbor complained, which is often the case. Generally speaking, when there's regulatory action, someone's probably complained about you. And so the EPA halted the construction and determined that the Sacketts were violating a federally protected land, and they ordered them to remove the gravel and immediately stop construction. The Sacketts sued, and they sued in 2008. And they primarily argued that the wetland that they filled was not a wetland that the EPA could regulate because it wasn't a water of the United States. And they also argued because there was dry land between the wetland and the lake was another reason why it couldn't be regulated. And so this case went up and down in the federal courts until 2023, when the final decision from the U.S. Supreme Court. So you can see, I mean, that's a lot of litigation. That's what, almost 14 years of litigation. And though they were successful, and the Sackett decision sharply limited the scope of the Clean Water Act protection for WOTUS. And while it didn't directly analyze the 2023 rule, it clearly made that certain aspects of the rule that the EPA had just published were invalid. So the Supreme Court determined in Sackett that the Clean Water Act only protects those relatively permanent standing or continuously flowing bodies of water forming geographic features that are described in kind of ordinary language, right? Streams, oceans, rivers, lakes, things that we would traditionally think of as navigable. And that it, and this is the important part, is that it only applies to wetlands if they have a continuous demarcation between waters and wetlands. And essentially, the Supreme Court said, look, it's got to be difficult to determine where the wetland ends and the WOTUS begins.
Well, it sounds like Supreme Court decision changed the manner in which an agency can determine what constitutes a WOTUS.
It did. Now, in order for the federal agency or a state agency acting under, a federal permitting under the Clean Water Act, basically has to show two things. First, that the wetland actually, or that the adjacent water body actually qualifies as a WOTUS. So if the adjacent water body, say the lake in Sackett wasn't a WOTUS, then it ends right there. But they also have to show that a wetland has a continuous surface water connection with that WOTUS, again, making it almost impossible to determine where one starts and the other ends.
Well, it seems like proving that a continuous surface water connection exists, particularly where you have areas of diffuse flow like wetlands, can be difficult. Hydrological studies, including modeling and flow measurement in upstream and downstream reaches, could be used to assess how a surface water connection to a WOTUS may vary seasonally. If flow is not contributed to the WOTUS year-round via the connection, then is it not considered continuous?
Yeah, and that's constantly the problem, right, with the WOTUS definitions, is the common person and the lawyers and the engineers can't necessarily just look at it and say, this is waters of the United States, this is a protected wetland. In some cases it's probably more easy, but in lots of cases it's not. So I do think that's going to be an issue. The Supreme Court acknowledged that temporary interruptions may sometimes occur, but gave no guidance, which is often the case. They answer the direct question, but they don't necessarily give guidance on peripheral issues. But gave no guidance like how long is temporary. So I guess from a regulated party's standpoint, I would argue that if it's dry part of the year, there's not a continuous surface water connection, and therefore it's not a WOTUS. But again, I really expect that'll either be subject to interpretation by the courts or further regulatory decisions. I also want to note that the MPCA has recognized that it's going to be difficult to determine this, and it's going to be, again, on a case-by-case determination, which obviously is very hard for the regulated party because it means probably experts and lawyers, which we all know costs money.
Yeah. What, if any, response did the EPA have after this court decision?
Well, and this is where the paper on your desk comes in, because the EPA revised the rule yet again in August of 2023. And they had to do that in response to the Sackett decision, because essentially the court said, look, your definitions that you had are no longer viable, and this is what the law is. So they removed interstate wetlands altogether, and they removed what's called the significant nexus test. So I talked about, and you saw in the earlier slide, where it will significantly affect. And significantly affect meant a material influence on the chemical, physical, or biological integrity of waters. Again, that's a pretty difficult term to try and prove, and difficult for a common person or anyone to actually analyze. They also removed intrastate streams or wetlands, and they amended the definition of adjacent to mean a continuous surface water connection. And that was in line with the Sackett court, that it had to be a continuous surface definition. So this is much more narrow definition than we have really ever seen, at least since, I think, probably dating back to 1972.
What, if any, effect does this have on the regulatory community?
So the interesting part is some have surmised, different legal experts, that the Sackett decision essentially removed about 50% of the wetlands in the nation that previously would have been covered under the Clean Water Act. So that's a significant reduction, and in fact, that's a bigger reduction than we saw when Trump administration amended the rule in 2020. So my guess is that there's going to be significant litigation, both, I know various industry groups, I believe American Farm Bureau still says the definition is too broad, it's not understandable, they'll likely challenge it. But on the other hand, we have a lot of the non-governmental organizations that will also likely challenge it, or they may try to bring actions, other actions, not necessarily using the Clean Water Act, so that they can achieve whatever goals they may have. Now, the state of Minnesota has provided a preliminary assessment. They often do some work papers, so they might give it to the governor or the governor's office, just kind of like, what is the assessment of the SACA decision? And, I agree with them that there's going to be significantly reduced federal jurisdiction over wetlands when there's no continuous surface water connection. And I think that would have happened despite if it was going to be a Democrat or a Republican administration because of the Supreme Court. The state also agrees that it's going to be very unclear as what is indistinguishable. Where does the wetland stop and the WOTUS begin? And that's going to be subject to issues. They also, and I think this is important, noted that this does not change the right of a state or a tribal authority to be more environmentally protective. So
I presume that this means that with more limited role of the federal government and the new administration, that we're likely to see increased activity by some states.
Yes, and I've lived through and worked in the government during a number of different administrations in the federal level, and generally speaking, if you see the federal government kind of limit or parcel back on regulatory authority and the states think it's important, you'll see the states pick it up. So, and especially depending on what administration might be in office and what state you are, but you can anticipate that Minnesota will probably try to fill some of the gaps and increase their enforcement activities in light of the EPA and the Army Corps having a much more limited role. So there's two primary permits that you may know under the Clean Water Act. Section 404 permit and a NIPDES, National Pollution Discharge Elimination System, but I just call it NIPDES because that's way too much to say in one sentence. Under the Clean Water Act, a Section 404 permit is required for the discharge of dredged or filled material into a WOTUS. And remember, the WOTUS can include a wetland, so if you're operating and you're digging up ground and you're dumping it on an area that constitutes a wetland, that could be a violation, or you need a Section 404 permit. The discharge includes the redeposit of dredged material other than incidental fallback, but the good news is that most routine ongoing farm activities are exempt from a Section 404 permit.
Karen, what are some of the exemptions that are applicable to agricultural community?
So these are the general exemptions that I have put up. They include ongoing farming, ranching, and silvicultural activities, maintenance, but not the construction of drainage ditches, construction and maintenance of irrigation ditches, farm or stock ponds, farm and forest roads, and then again, maintenance, but not construction of structures such as dams, dikes, and levees. I have a friend with last name Levy, so that's where
I hate to ask this question, but are there any exceptions to the exemptions?
Of course. Yes. The exceptions are not going to apply if there can be two factors met. One is a new use of water. And that kind of ties in, right, with the ongoing farming operations. I mean, if you're going to increase farming operations and it's a new use of water, then the exception's not going to necessarily apply unless you fall in one of the other categories. But they also have to show that the activity would result in a reduction of reach or impairment of flow or circulation of regulated waters. So I put a few type of exceptions. For example, I mentioned that bringing a wetland into farmland production where it was previously not used for farming. And these are exceptions that you can find on the EPA's website. So converting an agricultural wetland into a non-wetland area. And then I think this is really important, Todd, that changing the location or the footprint of the ditch, so you can maintain the ditch, but you can't expand it. So you can't make it wider, you can't make it longer necessarily without considering whether you need a permit.
Yeah, that one in particular could be a real pinch point, and we're going to talk about some of this later with managing rainfall and runoff from your operation.
Yeah, I mean, just from my standpoint, again, this is the problem with these statutes, right? What does it mean that it results in a reduction of reach or impairment of flow or circulation?
Well, that's just if you're essentially if you're robbing flow from the stream so that it doesn't now flow as far or as much. So while on the one hand you're trying to control runoff and not have too much runoff from your field going into the ditch, you also can't have too little. So it's really sort of a pinch point here that these multiple overlapping regulations put on the operators.
Again, and NIPD's permits, they're issued either by the state or the federal government. Certain states have permitting authority, and Minnesota is one such state that has permitting authority. And the NIPD's permit is going to set limits on what you can discharge and specify an acceptable level of a pollutant. So you may be able to discharge a pollutant, but you might have a limit. So example, for like sulfate or nitrates, it might be a 10 milligram limit, depending on what the rule says. And then it's also going to include monitoring, reporting requirements, and it's going to be tailored to your operations depending on your discharge. I know, if you have a concentrated animal feeding operation, you likely are going to be aware of a NIPD's permit and may have had to apply for one depending on what your operations are doing. So we're going to get to the next Supreme Court decision, but traditionally the state of Minnesota regulated groundwater and non-point source pollutions. And the EPA really only stepped in to provide guidance, do studies, provide research grants, and so their role was pretty limited. But as a result of the 2020 decision from County of Maui, the EPA was granted additional authority that it previously had not had. The County of Maui, which of course was in Hawaii, and it was a number of environmental groups that brought action against a wastewater discharge entity. And while the Clean Water Act has always prohibited the discharge of any pollutants through a point source into a water of the United States, County of Maui found that the Clean Water Act is also required, and a permit is required, when there's a functional equivalent of a direct discharge from a source into navigable waters. So courts and companies across the country are now dealing with how to factor in the County of Maui ruling. It's very important to review when evaluating subsurface or land disposal of pollutant containing discharges that may reach groundwater with hydrological connections to a navigable water. Todd, can you give us a background, just a short background of the facts and a quick pictorial overview of what the County of Maui decision is now requiring? I just feel that in concept, it's really hard to see what is a functional equivalent of a direct discharge.
Yeah, sure. So in that case, the background facts were that the County of Maui was operating a wastewater treatment plant, and the discharge from that plant went through a few miles of pipe and then was injected into deep injection wells for disposal that were, quite deep indeed. But the effluent, which was about 4 million gallons a day, traveled half a mile or so through the groundwater to the ocean. So this is just sort of a general cartoon of what we're talking about here. Can I use this deal? So most folks are familiar with what a direct discharge is. So example, you may have a lagoon or a pit overflow for a CAFO. This is water comes out of a pipe and into the water of the U.S. here as a direct discharge. Now the methods for characterizing the flow and the quality of these direct discharges is pretty straightforward and well established, and also the solutions to achieve compliance for direct discharges are also very well established. However, can you scroll up a little bit? However, the Maui case found that discharge of wastewater via transport in groundwater to the groundwater surface water interface could be considered functionally equivalent to discharge from a pipe based on certain factors. And that MPDS compliance could be enforced in the groundwater in this case. Now, transport via groundwater and discharge at the groundwater surface water interface is not as simple as a direct discharge. I mean, you can just think about it, you know, you have a pipe versus water moving through the subsurface materials. While there are tools for characterizing flow and quality of these types of discharges, these tools have not been applied to evaluate the functional equivalency factors before, nor have they been applied to evaluate compliance of groundwater with MPDS permit limits. Similarly, while treatment processes to achieve compliance with groundwater quality standards have been applied to remediation problems, they have not been applied to achieve MPDS permit compliance. So Karen, can you tell us some more about what we've learned from the Maui case so far?
Okay, so what is the functional equivalent of a direct discharge? Basically, the Supreme Court stated that whether pollutants arrive at a navigable water, or WOTUS, after traveling through groundwater from a point source will depend on how similar to or different from the particular discharge is to a direct discharge. So when it actually reaches the WOTUS, is it very similar in characterization as if it had come straight out of a pipe? And the court elaborated that where a pipe ends a few feet from a protected water, and that the pipe emits pollutant that travels through the groundwater or over the ground, the permitting requirement clearly applies. However, if it travels 50 miles away from protected waters and the pipe emits pollutants that travel with groundwater and mix with other materials, end up in the protected water many years later, then the permitting requirements likely do not apply. But again, you see those are two very far ends of the spectrum.
So while recognizing that every case is different, the Supreme Court provided some factors that may come into play. The Supreme Court indicated that transit time and distance traveled would certainly be important, but also identified other factors, including the nature of the material through which the pollutant travels, the extent to which the pollutant is diluted or chemically changes as it travels, the amount of the pollutant entering the WOTUS relative to the amount of the pollutant that leaves the source, and the manner by or area in which the pollutant enters the WOTUS. Also, the degree to which the pollutant at the time it enters the WOTUS has maintained its specific identity.
Now, I just want to make a side point here because Todd will be talking about this issue later. But in the County of Maui case, they admitted a whole lot right at the beginning. So they admitted, that it traveled, that it was a pollutant, and that when it reached the WOTUS, it was a pollutant. In hindsight, if they had worked with attorneys and technical advisors at the beginning, they may not have had to, provide all that information at the beginning, or they could have done some additional testing that may have caused it to be different than what the end result was. And so that's just one thing to think about when you are looking at any type of enforcement action or lawsuit is, considering what test you're going to do. And Todd's going to discuss that later. But I think when we look at these factors, and there's a lot of them, and discuss them today, we see that they're pretty much intertwined, and that there's a lot you can do to distinguish your operation. How would we start a conversation about how the functional equivalency factors might apply to a given setting?
Well, first you have to decide what types of answers you need to do that, and then you use the proper tools to get those answers. So here is an example of groundwater modeling used to trace a flow path and travel time of water from a source to a receptor. We can also trace the path and travel time for a wastewater constituent, which may have a longer travel time or a lower concentration due to interaction with the aquifer material. The degree to which a constituent's velocity is slowed relative to the velocity of the groundwater is characterized by what they call the retardation factor. As you can imagine, retardation factor of a pipe would be very low because it just moves straight through with the water. But in the ground, it may be absorbed on different surfaces and it may move more slowly. So that's an important example, an important factor to consider.
Well, and it also may change. What might be a pollutant that enters the groundwater by the time it's moved through rock, sand, other materials, and cleansed itself, it might not actually be a pollutant still. by the time it actually enters the WOTUS. So as I mentioned, the Maui case has caused disruption in the industry and the regulatory community, but there are many things you can do to determine whether your situation is different. I think one of the first things that operators want to look at from the outset is what I just mentioned. How different is what leaves the point source to what enters the WOTUS?
Yeah, that's what needs to be determined, whether or not the water reaches a WOTUS, is a pollutant, whether it is a pollutant or if it's different enough that it's not the functional equivalent of a direct discharge. This is also what the regulators will be trying to determine. In the County of Maui, there were a number of factors that were not analyzed, such as what happened to the wastewater as it traveled to the ocean. Did it all actually end up in the ocean? And was it still a pollutant, or had it chemically changed along the way? They didn't really look at any of that.
Yeah, that was kind of my point about just making preliminary statements and admissions that this is what happened, versus actually analyzing, was it even a pollutant when it entered that water? So the future is going to be uncertain after the County of Maui decision. It's likely that agencies and courts across the country are going to apply the functional equivalency test differently, and more operators and facilities are going to need a NIPDES permit or be subject to permitting enforcement actions. We're likely going, although we haven't to date so much, but we're likely going to see more litigation brought by environmental groups. I mean, they were successful in the County of Maui decision, so you may see more of that. So as far as the regulatory community, you may want to consider what actions you can take, determine whether your discharge is reaching groundwater, such that it may be determined to be a functionally equivalent discharge. Are there steps that you can take to prevent that determination, and do you want to proactively apply for a permit? And interestingly, I mean, both the state and federal agencies have also been grappling with what to do with County of Maui. I don't know that the MPCA has actually issued a decision on what is the functional equivalent, or whether there is a functional equivalent, and determine a NIPDES permit. I know a few years ago they were looking at a mining operation, but I'm not sure that that has actually been determined. I think there might be more studying being done. And even the EPA, even though this was decided in 2020, the EPA just released guidance in November of 2023 about the case. And it really wasn't all that helpful. It essentially relied on the County of Maui factors and said, but it did say that even one factor could trigger a permitting requirement, and that it was case specific. And that the weight of the factors, of course, is again left to the agency discretion. So you have the issue where the agency is going to be determining what weights applied to what factor and what happens, and then they're going to make the decision, which of course would then have to be challenged if you don't agree with that. I don't expect to see much in this area from the federal government, at least not during the next 4 years. I don't think this is going to be a high priority under the Trump administration, and so, but you may see some activity from the states, although it's been slow so far. Okay, in case you're tired of Supreme Court decisions, there's just one more I want to talk about, and that was the Loper decision in 2023. So while the Sackett decision was very good for the regulatory community, the regulated parties, and the County of Maui wasn't so, the Loper decision is a very good decision for the people who are operating businesses, agricultural operations. So this was issued in 2023. It involved a challenge by a group of fishing operators that they were required to have an observer, and they had to pay for the observer on their boat while they were fishing so that they could monitor their operations. And they challenged that, saying that that wasn't a reasonable interpretation. So what happened, though, is the underlying court found that the statute and the authority was ambiguous, but because the agency's interpretation was a reasonable interpretation, we're going to defer to the agency interpretation. And this has been the case since about 1984. Thus, even if there's multiple reasonable interpretations, if the agency has interpreted that way and their position's reasonable, generally speaking, the court deferred to the agency and the agency won. The Loper decision changed that. They said, the Supreme Court said, that a court must exercise its independent judgment in deciding whether an agency has acted within its statutory authority, and not simply defer to the agency. And I say this is important because it really levels the playing field, where you're not stuck with just because the agency has a reasonable interpretation, the court's going to defer to it. And instead, you can now make the agency prove why their interpretation is the correct interpretation. And regulated parties can challenge that, through legal arguments, industry practices, technical expertise. And so this has caused a lot of stir in the community. Obviously, a lot of the environmental groups and other operators are very concerned about this decision. And then a lot of people who are the ones who are subject to the permitting feel that it's a positive and a fair decision, because the agency doesn't get to just walk in and say, this is the way we do it, we win. And they actually have to prove what they're doing.
So now we're going to turn the discussion a little bit and talk about nitrate, because there seems to have been a lot of continued focus on nitrate entering the water systems in recent years, hasn't there, Karen?
Yeah, and I'm sure you're all aware about the April 2023 petition by a non-governmental operator who filed an emergency petition under the Safe Drinking Water Act with the EPA for the Southeast Karst region in Minnesota. November 2023, the EPA agreed further action was needed and requested that Minnesota develop a plan and provide education and outreach. The state stated that the enhanced long-term strategies would include reviewing and updating existing strategies, plans, and rules to reduce nitrate inputs into the drinking water. And in particular, one of the statements they said is reducing nitrate contamination in drinking water wells will require overlapping approaches that include both regulatory and voluntary actions that are science-based and will reduce all sources of nitrogen from to our waters and work at the state, regional, and local levels.
So, Karen, as you know, the state has also already been working on an update to the nutrient reduction strategy, which is proposed to be published in 2025.
Yes, the first nutrient reduction strategy, at least I believe it was the first, was in 2014. That was the last one, and that was a 10-year plan. The state is revising the plan, and it's expected to come out at the end of 2025. They don't have a whole lot on their website about it. I know they have done some public comments, and they have said that the strategy is going to address both point and non-point sources. And they also have some pretty hefty goals, as you can see. They're asking for a nitrate reduction of 25% by 2025 and 45% by 2040. Which is not that far along from now. I also want to, here's some of the nitrate facts that the EP or the MPCA does have that have they made public. They have found that 70% of the nitrate in Minnesota waters is from cropland. They've also said that in tile cropland, most of the rainwater that ends up in surface water flows through tile drainage. They indicate that that's probably higher in nitrate overall, but it's also potentially easier to control, and I think Todd will talk about that a little bit. In non-tile cropland, most rainwater flows through the ground to get to surface waters, and they recognize that as it travels, some of the nitrates are removed. It's kind of like the county of Maui, right? As it travels, some of it's going to be removed from the natural process, but that's much harder to control. So this is just a few things that they have on their website: manage infield nutrients, manage and treat the drainage water, diversify vegetation landscape. I know they're big proponents, I know from hearing various speeches here about cover crops, etc., and buffers.
Sorry, is it okay to ask a question
Sure.
about this?
Yeah, go ahead.
So do you know if there's any nitrate facts on like the Minnesota water quality, like using and planting perennials, keeping roots in ground to try to control that water flow on farmlands? Has anybody looked at that?
Well, I think, and I'm going to talk a little bit about this later, but I think there are a lot of things that certainly that I've heard here in the past couple of days and that folks are working on to try to build soil health that translate. It's sort of the other side of it, right? You're trying to keep the soil healthy by keeping nutrients in the soil and on the field. And the flip side of that is you keep it out of the water, right? Now, a big part of what I'm going to talk about is how do you, so if you're doing these things and you're collecting information about it, how do you get to take credit for that from the standpoint of what's, you know, if somebody's going to come along later and say, all right, look, you need to reduce what is coming off of your field. And you've done all of these things, you've been doing them for years. How do you turn around and say, okay, well, look, I've already done that? How do you show your credit, right? So that's an important part of this. And so it's a very good point. It's a gap, I think, but it's good to be aware of. It seems like the MPCA may think that there's some lower hanging fruit in agricultural sources that will help them achieve their nitrogen reduction targets. If we do some quick math, the MPCA is looking for an additional 20% reduction by 2040. If non-agricultural sources account for 30% of the nitrogen, MPCA would have to eliminate most of those sources in order to achieve their target by 2040. Alternatively, they could look for some of that reduction in the 70% of nitrogen currently attributed to agriculture. So here we'll shift gears a little bit. We're getting to the engineering part of the presentation now. And we want to talk a little bit about different risks that producers may want to think about as a result of all the stuff we just went through previously. We're really focusing on two types of risks here. The first type is risks driven by changes in stormwater runoff volumes. This is actually something Ray talked a little bit about yesterday, the additional water in the hydrological cycle and how that's fueling some more intense and severe precipitation events and rainfall. So some of these risks could be erosion or inundation of fields, increased volumes of overflow for CAFOs. And then the other area of risks is really risk driven by restrictions on nitrogen discharge into WOTUS.
There's some permitting limitations on stormwater ditch improvements that can be made under WOTUS, and potential for future regulatory changes for nitrogen and runoff, tile drainage, and CAFO discharge.
So here, this is a schematic that just shows an overall approach that you could use to assess your risks and prepare tools and practices to address those risks when the time comes. We'll go into a little more detail on each of these steps in the following slides, but generally the steps are: first, gather information about your operation and surrounding water bodies. Like I mentioned, there's already a lot of this going on, folks documenting their soil health improvement efforts, but also information just about how water moves through your property. Assess your physical risks due to flooding or overflow under wetter future conditions or more intense future rainfall. So this has to do with thinking about not just what has been for the past 50 years, but what will be in what comes. Then you assess your regulatory risk due to proximity of your operation to a WOTUS. And then finally, develop tools and practices to keep in your pocket if you need them in the future. Now, we always try to start with the end in mind here. So overall goal, to have something useful here, is to try to come up with a cost benefit for different alternatives that you could use to address these risks when they arise. So by that I mean, how much can you reduce your risk? Can you quantify that? And then of course, as a producer, you know your operation better than anyone and what it would cost to implement certain strategies on your operation.
Because this approach requires collecting and working with specific information about your operation, it is worthwhile to consider whether or not you want to retain an attorney to seek legal advice as to what your regulatory requirements might be. The benefit of that is if you are directed to do certain tests, etc., as part of the attorney's review of the situation or working with your technical expert, that can be protected as attorney-client privileged material. And I also want to just mention, right, that I mean, part of the strategy too is not even from the regulatory risk, but are you spending money that you don't have to because you're just losing those nitrates?
Mm-hmm. Yeah, likewise, I have a note here to try to limit collection of new flow or water quality data, at least at the early stages. That data is tricky to collect, If you don't do it right, you can get spurious results. And it may even paint a picture that's inaccurate about what's going on with your operation. So instead, focus on tabletop, what we call tabletop exercises, models with appropriate assumptions, just to get an initial idea of what your options are. So what type of information would you collect? And the simple answer is, well, anything that helps you understand how water moves through your operation on its way to a WOTUS. So most of that information you can get from surveys of the area. But it also, Karen, seems like the proximity to the WOTUS is a pretty important piece of information. How would you go about starting to determine that?
I mean, some of this you can start looking at what's in nearby navigable waters. For instance, you know, the Minnesota Pollution Controllers, the DNR, one of the state agencies, as DNR, has a public waters inventory. So you do know at least what the state has already determined as the public waters. And then you can evaluate what water in between may or may not qualify as a WOTUS.
Then your next step is assessing that physical risk. So you take a look at that by modeling your drainage system, looking for choke points that might cause backups or areas of high velocity that could contribute to erosion. Using models and projected climate scenarios, we can assess the risk of flooding. For CAFOs, we can model a frequency of overflow. And it's important to note that for CAFOs, the characteristics of the 25-year, 24-hour storm event, which is used in the design basis of those facilities, that's changing relative to historical characteristics. Storm volumes and intensity are increasing in some areas, and this could result in larger volumes than anticipated, and thus compliance of the facility may depend on what definition the MPCA uses for a 25-year, 24-hour storm. Karen, if a storm smaller than a 25-year, 24-hour storm caused an overflow from a CAFO, what would be the consequence of that?
That could be considered a violation of a NIPDES permit or the lack of having a NIPDES permit. So, and I think the 25-year, 24-hour storm, I haven't actually looked at this in detail, but you know, when is that definition going to apply? Is it the definition of what was 15 years ago, or is it what is a 25-year, 24-hour storm now? I mean, obviously, if you're the regulated party, you want to go back to the original definition, and if you're government, you're going to try and use the more current definition.
Once we understand how water needs to move across your property, we can look at how the soil and nutrients may move off-field and how that's affected by changing precipitation conditions. Some information related to soil health could be useful in estimating soil and nutrient movement by water through different parts of the drainage system. If we can find where the soil and nutrients are moving during the storm event, then we can look at modifying what's happening there to either keep the soil and nutrients from getting into those drainage features or to remove or retain the nutrients within those features. Karen, the question of what water bodies adjacent to a WOTUS may be a WOTUS seems important here.
Yeah, again, it would, you know, you want to look and see if there's anything that indicates that there's a WOTUS near your operations or that you think that your drainage is somehow eventually going into a WOTUS. I mean, as I mentioned, there are agricultural exemptions right now under the Clean Water Act permit that still apply. But of course, we're mainly talking about the federal, and the state has its own regulatory statutes involving wetlands, et cetera, and their own enforcement authority that differs than the Clean Water Act.
You know, hopefully the hydraulic connection will be pretty clear-cut, but if it isn't, you might have to collect some flow measurements upstream and downstream and then do some statistics to see how continuous it is. And on the last step, and this is my favorite step since I'm an engineer and I like to solve problems, we can use the same models that we made in the previous steps to evaluate how different practices and modifications could reduce your risks. For example, we could model upgrades to stormwater conveyance ditches to assess how much that will reduce the risk of flooding. We can model different drain tile operational practices, such as draining different segments at different times instead of everything at once. We can model different stormwater segregation methods to reduce the risk of overflow from a CAFO pit or lagoon. And we can model different in-field practices to assess the reduction in nitrogen or soil loads to a WOTUS. Karen, are there any legal tools to reduce risks, or are we stuck with just engineering?
I mean, it really kind of depends on what you're facing. If you're in face enforcement actions, your goal is going to be demonstrating that you're not discharging to a WOTUS and that you've not otherwise disturbed a wetland, be it federal or state. I mean, similar to the socket, but hopefully not for 14 years of litigation. You want to be able to prove to the state that, or the federal government, that what you've done has not violated the law. Generally speaking, when I'm working with clients and they're looking at doing something, or even if they have done something, I do try to approach the regulatory agency. I found that if you tend to be cooperative with them, ask questions, ask for guidance, that they're generally pretty eager to help, and that they will give some practical solutions. And also it gives you an opportunity to say, this is what I want to do, and this is why I think I can do it. And then can you tell me if there's an issue with that? So that can be very helpful and cost saving in the long run. No one wants to get into litigation because it's just very expensive.
And then the last part of this, and I had alluded to this earlier, is to take credit for doing the right thing. Make sure that you can document that credit. Knowing the costs and benefits of what you can do can help you really lead the conversation about what is right for your operation. In taking credit for these improvements, sometimes there are programs that can be helpful for that. Such as the Water Quality Certification Program for the Department of Ag. That's one example. We probably need more to encourage folks to do the right thing and to document the credit for doing that, so that later on, when folks start asking, what have you done lately, you can point to that and say, okay, look here, this is certified that I achieved these sorts of reductions by doing these practices.
And I mean, you've done a lot of good things already. I've heard about it and the different things, and the key is that you do want credit for that. Say there's a new rule implemented, right, and you've already done all this work. You shouldn't be at the same situation as some other agriculture producer who hasn't done anything. You should be receiving credit for that. I just want to say, too, that you have a strong voice. You've got a 1,000-person membership. Worked in government for a long time. I've been always surprised at how few people it can take to change the law, to change an agency's perspective. I mean, if we got 10 letters on a subject, that was deemed to be a big issue, and people would stand up and take action. So you can just imagine that, if you're a big group like you, and you can advocate and say, look, there should be programs in place for us, not just this water quality, but other programs, so that maybe we can get grants, or just to protect us and to demonstrate that we don't have to comply the same way other people do. So we are at the conclusion. I know we're running out of time.
I guess in conclusion, what's it all mean? There are multiple legal and regulatory areas where there's a lot going on, and it suggests potential future regulation of drainage infrastructure, quantity, and quality. What can you do? Protect your privileged information, evaluate your risks, understand the cost-benefit, and keep your tools in the toolbox until they're needed, or at least until you can get credit for doing those things. How can you be part of a broader solution? You know your operation better than anyone. Make sure you also know your risks and solutions better than anyone, and lead that conversation when the time comes. And as Karen was saying, participate in the public comment opportunities or rulemaking, and engage with public officials as a group wherever possible.
So thank you. We're both members of the organization, but this is actually our first Premier Soil event, and we've been very impressed with all the presentations and meeting and all the things you already have done. It's a pretty remarkable group, and we really appreciate the fact that you allowed us to speak and give you some points today.